Testing, Judge microphone 1. Testing, Judge microphone 2. Testing, Judge microphone 3. Testing, Judge microphone 4. Testing, Judge mic 5. Testing, Judge mic 6. And Judge mic 7. Appellee lapel mic testing. All right. And appellant lapel mic testing. Honorable Justices of the Supreme Judicial Court, sitting in the law court at Portland within the state of Maine, may come forth and declare it, and they shall be heard.
Good morning. You can be seated. And the first matter before the court this morning is Kennebec 24-450, Andrew Robbins et al. Versus Maine Commission on Public Defense Services, State of Maine, et cetera. I see counsel are present. What I am going to ask is that counsel who are going to be arguing would identify themselves together with the party you represent for the record, starting with the appellant.
Good morning, Your Honor. Paul Suter, Assistant Attorney General on behalf of Appellant State of Maine.
Good morning, Your Honor. Jordan Bach, and I'm representing the appellee plaintiff class.
Thank you. And we are being streamed, as a reminder, on the web, both by audio and by video. And Attorney Suter, if you're ready to proceed, we'd be happy to hear your argument here this morning.
Thank you, Madam Chief Justice, and may it please the court. Count 5 is entirely duplicative. There's no declaratory relief that Robbins could obtain against the state of Maine that he couldn't also achieve through an action against state officials. Recently, he's insisted that Count 5 merely seeks a declaration that Maine's process for appointing indigent counsel violates the Sixth Amendment, and that Count 5 is necessary to govern the relationship between him and the state going forward. Except it won't. Rather than providing for meaningful relief, Count 5 actually acts as a barrier to it. To illustrate, declarations and injunctions against official capacity defendants already run against the state of Maine, and they can actually bind officials and agency heads in future litigation. If officials ignore a binding precedent, they can be hauled into account in contempt proceedings. But that's not true for vague declarations or injunctions directed at the state of Maine. Moreover, permitting Count 5 to proceed would raise a hornet's nest of novel legal issues, including questions regarding Count 5's enforceability, questions regarding its preclusive effects on state or federal litigation, and questions regarding separation of powers, like whether our Constitution permits plaintiffs to coercively bind together all three branches of government into a single defendant party, forced to litigate through the same counsel, and subjected to the same judgment. Ultimately, it's stare decisis that decides this appeal, because allowing Count 5 to proceed requires overturning decades of precedent in three distinct areas. First, Maine sovereign immunity can only be relinquished by affirmative acts of the legislature. Second, the DJA does not form the basis of an independent cause of action, even in anticipatory suits where it can be properly invoked. And third, standing evaporates if relief cannot meaningfully redress a plaintiff's injuries. Your Honors, I'd like to be as helpful as possible, and so I'm happy to take any questions that you have.
I have a question about a statement you made on page 11 of your reply. It said, here applying sovereign immunity to the state would not prevent Robbins from obtaining prospective declaratory relief under Maine's DJA against state officials. So are you waiving any sovereign immunity as to officials, individual people, as opposed to the state as an entity in Count 5?
So, Your Honor, I don't know that I would have the power to waive sovereign immunity as counsel for the state of Maine, because those individual officials are not my clients. But what I will say is the Attorney General's office does not invoke sovereign immunity in properly brought anticipatory cases that challenge the constitutionality of the statute.
So if this, in Count 5, who's the right defendant in Count 5?
I believe, ultimately, I would leave that to the plaintiffs, but I think that they have named the correct defendants in Counts 1 and 2, and the declaratory relief that they're seeking can be...
So the commission, the AG?
So Count 1, what remains was brought against the commission's members. The AG was named and the governor was named. They were dismissed for, I believe, reasons unrelated to sovereign immunity. And so if they had been proper defendants for purposes of the relief that plaintiffs seek, then certainly they would also be potentially the correct defendants. But I think that they've named the correct defendants insofar as they are attempting attempting to challenge the implementation of Maine's indigent defense system.
So to be clear, you haven't raised sovereign immunity as a defense in counts 1 and 2, and you don't intend to?
That is correct, Your Honor. And I just, Justice Douglas, I want to be clear that other counsel is representing the commission in counts 1 and 2, but sovereign immunity has not been raised.
Has it been raised by other counsel?
No, Your
Okay,
Honor.
so it is not an issue as far as counts 1 and 2 in this case are concerned?
That's correct.
Okay. Who is the real party in interest in this case?
So I think the real party in interest as it relates to counts 1 and 2 are state officials in their official capacity. And so typically the way that works is their actions or inactions are examined, and if their actions or inactions are violating the Constitution, a court is certainly permitted to issue declaratory relief related to what those officials have done or haven't done,
But
and that declaratory relief runs against
the
state.
constitutional obligation here does not reside in any one official or in one agency. It resides in the state.
That's correct, Your Honor, but in any constitutional case that challenges state action.
Well, what about that? What about takings cases?
Typically, I believe folks would pursue the government official responsible for the taking.
But the state is not immune in a case where someone is seeking to vindicate their Fifth Amendment property rights, is it?
I don't think the state would be immune if the official responsible for taking their property rights was named as a defendant in their
Or
official
the
capacity.
state. There are cases where there are takings claims against the state, and because the right to compensation is included in the Constitution itself, you can sue the state.
So, Your Honor, I do think that there is an important distinction between property cases and cases unrelated to property. This court certainly recognized that in Welch and reaffirmed it in Knowlton, that sovereign immunity, when it comes to the ownership of property.
But a takings case is not ownership of property. In fact, it's the obverse. I mean, you know, it's somebody claiming that the state has taken away rights, not necessarily by title. It may be by title, but it might not be.
So I think that is a fair point, Your Honor, and if that issue were to be presented to the court and the court were to determine that there was no way of obtaining meaningful relief against that violation, then perhaps it would be appropriate to recognize that sovereign immunity doesn't apply. I'm not aware that that has ever been offered as a defense in that type of case, and that is certainly why there's not a body of case law that addresses that.
If this is meaningless relief, why is the state spending all your time and resources in trying to get rid of this claim if it doesn't do anything?
So I think the real issue with this claim is not so much the relief that plaintiffs have focused on in their briefs. It's what the implications are if a plaintiff can bind together the entire state government, all three branches of government, and have it defend some aspect of a statute or a governmental action or inaction.
In your opening statement, you led off with sort of a high-level policy question to the effect of a parade of horribles if a declaratory judgment is issued. I think you said it was some vague pronouncement of law. It's going to tie people up down the road. But the other side of that coin is a well-crafted, narrow, and clear declaratory judgment can be a wonderful benefit to all of the entire state to say, here's a clear pronouncement of what the law is. So it's not necessarily a parade of horribles. A declaratory judgment can serve a very positive purpose.
No question that a declaratory judgment can serve a positive purpose, and there is nothing about eliminating count 5 that prevents the plaintiffs from seeking that declaratory relief against state officials, which again do run against the state government. So any declaration that a state official has violated the Constitution is a declaration that the state government has violated the Constitution.
But you're still opposed to the declaratory judgment mechanism?
Not opposed to the declaratory judgment mechanism, Your Honor. Opposed to a declaratory judgment brought against the state of Maine as an independent cause of action.
Because you think somehow it's broader relief than against the officials, which you said are fine?
The problem lies with the fact that for example, declaratory or injunctive relief, which the complaint does seek against the state of Maine. Typically, in order to enforce that, parties need to be bound by the declaration, and it doesn't seem likely, if constitutional, to bind parties that haven't had the opportunity to be heard on any given issue. And so, for example, if a party were to seek relief or seek additional rulings on behalf of this declaration that was issued against the state of Maine as a whole, against, let's say, a member of the judiciary or a member of the legislature, that could create serious problems if the judiciary and the legislature didn't have an opportunity to participate in the litigation that resulted in the declaration. That's the real concern here. Genuinely not in this case. It's in other cases how this precedent could be applied.
Let's assume for a moment that we were to decide that the state is not immune. Are any of the declarations being sought in Count 5 ripe for our review at this point? Or there's a whole nother phase of this litigation, is there not? And how does that phase 2 affect the issue, this issue, and other issues that are before the court in both of these appeals?
So it is true that, that there are other phases in the litigation, and I want to address your point directly, Justice Douglas, but I'll first point out that the state of Maine actually hasn't answered the complaint at all yet, although it was forced to go to trial on phase 1. And so there hasn't been any discovery in phase 1, and there is also a phase 2 portion of the litigation in which the plaintiffs are seeking an injunction and declaratory relief. And so I don't know if it's clear if every aspect of this case would be ripe, although certainly whether or not injunctive relief against the state of Maine as an entity seems to be only a legal question that would be ripe for review right now.
That's been dispensed with, hasn't it?
It hasn't, Your Honor. We're on appeal from a motion to dismiss, but the state was kept in the litigation as this progressed to trial, and the Superior Court initially said it might issue injunctive relief as a result of the trial, and then after some legislation that was passed, it said that it was no longer necessary as to phase 1, but it is still an open question as to phase 2.
What is at issue in phase 2?
So phase 2, my understanding, is related to the original complaint that was brought alleging that the quality of counsel provided to indigent defendants is not adequate.
Thank you.
Thank you, counsel.
Thank you, Your Honors.
And Attorney Bach, we're happy to hear your argument this morning.
Thank you. Good morning, Your Honors, and may it please the Court. Jordan Bach on behalf of the plaintiff class. Gideon v. Wainwright makes the guarantee of counsel, quote, obligatory upon the states. This Court's decision in State v. Watson says the same. For those who cannot afford counsel, the constitutional right imposes an affirmative obligation on the state to provide court-appointed counsel. The state as an entity is failing to satisfy this obligation, and sovereign immunity does not bar an action against the state seeking a declaration that the state is not upholding this affirmative constitutional obligation to provide counsel. This Court has already recognized that a declaratory judgment action involving constitutional rights can proceed against the state as the state. As this Court said in Welsh, to allow otherwise would, quote, fly in the face of the constitutional protections and rights of the people. And a string of state Supreme Courts across the country have recognized, including in the Sixth Amendment context, that sovereign immunity does not preclude a declaratory judgment action regarding the state's affirmative constitutional obligations. The state objects that it cannot be sued absent a waiver, but the state does not have discretion to decide whether this court can adjudicate a constitutional rights of individuals. The state is also already participating extensively in this action as the real party in interest on the habeas claim. The state's remaining objections fail. On the Declaratory Judgments Act, plaintiff's claim arises from the right to counsel in the state and federal constitutions, and a string of cases from this court recognize that the DJA can be used as the vehicle to adjudicate a standalone claim for a declaration of constitutional rights. Finally, the state's standing theory is wrong. The state describes this case as advisory, but a declaration from this court regarding whether the state, as the state, is upholding its constitutional obligation would have issue preclusive effect in individual class members pending criminal cases and would thus provide meaningful, tangible relief to class members. I'm happy to take the court's questions.
So the Superior Court, in denying the motion to dismiss, basically said, well, sovereign immunity can't preclude the court from declaring the obligations of the state when it would otherwise permit the state to avoid accountability to its citizens for constitutional rights. Is this case different from any other case when somebody, we hear this every day in court, my rights have been violated, due process, whatever so does that mean that this should be essentially and can be a very common action, that anybody who thinks their rights have been violated can bring a DJA?
No, Your Honor. What we're requesting here would actually be quite narrow, and
Well,
it turns
tell
on...
me then how you narrow that. That seems pretty broad to me.
I think the nature of the Sixth Amendment is really key in two ways in particular. Both the state and federal constitutions impose an affirmative obligation on the state as the state to provide counsel. I think that's important here for two reasons. One, the obligation runs against the state specifically. Because of that, it is the state that needs to answer for the violation. I will
Yeah, but
note...
the state qua state doesn't act. I mean, it acts through agencies, through, one of the branches, et cetera.
Well, I think in this case in particular, so there was a claim against MCPDS, the
Right.
agency, and there, of course, the officers are still in the case. The claim against MCPDS was actually dismissed on sovereign immunity grounds because the constitutional obligation runs against the state specifically, was what the court recognized. And then in terms of the MCPDS officers, I think what's critical here is the MCPDS defendants have said throughout this case, they, quote, do not have the power to provide the relief demanded in plaintiff's proposed amended complaint. They've said they cannot provide the relief demanded, and they've repeatedly said that the ultimate party in interest is the state. So we have a situation where the Constitution imposes the affirmative obligation.
Yeah, but is part of that problem then the relief that is demanded? In other words, there are limits as to what a court can order, if you will, a legislature or the executive branch to do.
That's right, and we think that is why the declaratory relief we're seeking here actually walks the line of what is appropriate.
If you were to draft the declaratory judgment, what would it say?
We think it should be similar to the declaration the court answered against MCPDS, which is on 242 and 243 in the appendix, where the court declared that this is against the MCPDS defendants, that the
Okay,
MCPDS...
you're drafting the declaratory judgment now, so tell me what you would write.
The court declares that the state is required to provide continuous representation for all subclass members, and further declares that the state has failed to do so in violation of the Sixth Amendment to the United States Constitution and Article 1, Section 6 to the Maine Constitution. We think that walks the line of giving, as you were pointing out, Justice Meade, a clear statement of the law and the state's obligation, but does not actually impose a specific obligation. It does not direct the legislature to do anything in particular, and avoids the separation of powers concerns that the Superior Court has been very cognizant of throughout this case.
So now you've told us what you think the declaration should say. I want to know what you think, for example, in one sentence, the principle of this court should say as to when sovereign immunity would or would not apply. You've said that the Sixth Amendment is special, and I would like to know how that gets drawn narrowly from your perspective to permit this case, but not to just sort of say anytime somebody thinks their constitutional rights have been violated in any way, they get to sue the state.
I think the holding that we'd have in mind would be that sovereign immunity cannot be raised by the state to bar a request for a judicial declaration regarding the state's affirmative constitutional obligations.
So if it's an obligation of the state to refrain from interfering with certain things, as many of the obligations are, then no DJA.
Not at least for purposes of this case, no.
Okay? The state certainly has to afford due process generally. Is that something somebody can then do a DJA for?
I think what's different about the due process context is if the state violates, if there's an argument that there's been a violation of due process, then you can point to a particular problem. The court, there was not a public hearing. I wasn't given notice and an opportunity to be heard. You can point to the specific violation and the specific officer. In that sense, I think this is very different from, say, a Fourth Amendment claim where you have a search and seizure, committed by a particular officer. You can pinpoint the officer, and that's sort of how the Ex parte Young fiction runs. What is different here is the obligation is on the state, but I don't think the state can say, well, you can't proceed unless you can identify a particular officer. It is on the state to put forward, the mechanism to ensure that this obligation is respected.
I think I can hear Mr. Souter's mind going right now. He's saying, this will blow the doors open. We'll be getting declaratory judgments left and right for this, and it's going to create a whole new cottage industry of litigation. If in fact he is thinking that, what would your response be?
No, I think this is very narrow. I think this would not apply really to the mine run of constitutional actions. To start, we're talking about, I think, declaratory requests only, which is not sufficient, but I think it's certainly relevant.
Well, you're still seeking injunctive relief, though.
No, Your Honor, we are not. The Superior Court denied the request for injunctive relief on a summary judgment motion after a motion to dismiss, and we have not appealed that. So the injunction against the state is out of the case. I will also note briefly that there is no, phase 2 is in the future. There is no pending claim against the state in phase 2. The only pending claim we have against the state is the request for declaratory relief. So there is no concern, there is no live claim in phase 2.
How do you address the distinction that I think Attorney Souter has pointed to with Welch versus some of the other cases, that it may turn on whether it's proprietary activity, title to land, versus governmental activity?
I don't think that should be a distinction for 3 reasons. First, Welch in paragraphs 8 and 9 has extensive discussion of the importance of allowing suits to proceed to vindicate constitutional rights. I quoted some of that in the intro, but this court also said that the constitutional protections at issue would lose considerable meaning if the doctrine of sovereign immunity prohibited the people from bringing suit to vindicate a constitutional right. I think that analysis stands alone from the quiet title context.
That might hold if this were the only count in the case, but there are 2 other pending counts where those rights can be vindicated.
I think,
as Mr. Souter pointed out, this is somewhat duplicative of those.
I don't think so, Your Honor. Count 1 runs against the MCPDS officers, and the MCPDS officers have said throughout this case that they don't think they have power to provide full relief on this count, and that the lawyer for the MCPDS defendants has repeatedly said that the ultimate party in interest is the state. So I think MCPDS keeps pointing to the state broadly, which is why we added this count to the claim. And then on the habeas count, I think having the declaratory relief separate from the habeas remedial action is important to have the declaration of rights so that class members can use that in their individual cases. And I'll also point out, I think, the state argued in its brief that one of the purposes of sovereign immunity is not to entangle the state in lawsuits. But the state has recognized that it is the real party in interest in count 3. It is participating extensively in this lawsuit on count 3. So it is not as if this is the count that's going to pull the state into the...
It's a respondent in count 3, but if the commission has been dismissed on the grounds of sovereign immunity, did I hear you say that?
That's correct, Your Honor.
Doesn't that seem a little inconsistent, that the commission could be dismissed because it's immune and the state is not?
There were 2 justifications for the Superior Court's ruling, and we didn't...
Well, apart from the Superior Court's ruling, as a matter of common sense.
We didn't appeal that. I tend to think that actually MCPDS should have remained in the case, but I think there is an important distinction, which is,
Well, you probably couldn't have appealed that as an interlocutory appeal. I'm not sure, but anyway.
I think that may be right, Chief Justice Stanfield. But I think there is an important distinction here, which is the constitutional obligation runs against the state. specifically. And that was really motivating the Superior Court, and I do think the Superior Court was right to
So do all
recognize.
constitutional obligations. I mean, this is the problem, right? It's not just that when you say it runs against the state generally, not necessarily. I mean, that's really true for essentially all constitutional obligations. I mean, it might in our Constitution or in the federal Constitution allocated to a specific branch, but it doesn't say, and by the way, it's this agency that isn't charged with enforcing it or doing whatever.
Right, but I think if I'm understanding you correctly, that's really the key. MCPDS is not in the state constitution. The obligation runs against the state. So we have a scenario where...
But I guess what I'm saying is that kind of undercuts that somehow this is different, because that's true for all constitutional obligations.
Well, I think the Sixth Amendment is different in actually imposing an affirmative obligation on the state to do something affirmative, to provide counsel. That is, again, different from having, say, if you have a suit to say a state officer violated my Fourth Amendment rights, or I think this statute is going to violate my First Amendment rights. Those have identifiable officers.
So if I can say there's an affirmative obligation to get a warrant, or an affirmative obligation to provide additional, notice or opportunity to be heard, then you can do a DJA. But if it's a violation that instead of getting a warrant, you overstep something or didn't do something, then you can't.
Well, I think those have the distinction first that they're necessarily going to involve particular officers that you can identify. But even beyond that, I do think this is different in the sense that, if you're imposing due process limitations on the state, it's in a sense sort of a limitation on the state's actions. Whereas what this is saying is the state in a criminal prosecution needs to provide counsel to individuals.
Some state constitutions talk about how there is an obligation to provide a free education. And when there are claims that they haven't fulfilled that obligation through inadequate funding, there are suits against the governor, there are suits against the legislature, there are suits against individuals. You don't sue the state as an entity, do you?
Well, I think actually on the public funding point, the Claremont case in New Hampshire, admittedly, the initial portion of the caption is against the governor, and we haven't been able to track down the other defendants. But what the analysis there recognizes is that case was proceeding against the state as the real party in
Okay,
interest.
so now you're saying the Sixth Amendment isn't all alone. Now that's also another obligation that the state would be a defendant on a declaration too.
Well, I think to the extent that's another unique example of an affirmative obligation to provide public funding rights in that particular context.
But even there, by naming the governor, you're at least choosing which of the three branches the obligation goes to.
Well,
And was the governor dismissed from that action? I mean, the court ultimately made a declaratory judgment, but the governor was still a party, just as the commissioners here are parties, and a declaratory judgment can go forward. On that point, the cases that you mentioned, there's a string of cases across the country which allow suits against the state. Can you name a couple of them, any of them, which do not involve suits against individuals or agencies or departments, or where the state constitution doesn't specifically waive sovereign immunity?
Yes, Your Honor. I think the two best examples to give you probably are Tucker v. State, which was in the Sixth Amendment context.
That's the Idaho case.
Exactly.
That's a challenge to the public defender system, correct?
That's correct,
Yeah.
but it proceeded against the state. It's 162 Idaho 11, and the court specifically said that sovereign immunity doesn't apply when constitutional violations are alleged. The other example I'd give you that's cited in our brief is Kentucky Retirement Systems, which proceeded against the state as an entity, and the analysis there is helpful for explaining allowing the state to sort of preclude itself from judicial review in that case would be tantamount to a, quote, grant of arbitrary authority. And I see, if it's all right with the Chief Justice to add one closing sentence,
Yes.
I'll just say I think the constitutional rights here are critical, and you're balancing these constitutional rights against sovereign immunity, and I think it's important to keep in mind the broader context of allowing these suits to go into court.
Thank you.
Thank you.
Thank you, Your Honors. Paul Souter, Assistant Attorney General on behalf of the state of Maine. The relief that the plaintiffs have requested is available to them under count counts 1 and 2, presuming that they prove the merits of their claims.
How do you address their argument that the commissioners have basically, perhaps fairly, said there's a limit to what we can do here? We can't really redress the grievances.
Yes, Justice Lopez, and my response to that, without undercutting their counsel's defense, is that typically in those types of cases, those cases are brought all the time in court where someone is alleged that someone is violating the Constitution, and their defense is, I don't have the ability to comply, and the court's answer is, too bad, you're still violating the Constitution.
But there's a difference between, stop doing that, you're violating the Constitution, and you need to give this person something to conform with your constitutional obligations, and that, comes down to money and things like that. And so, again, counts 1 and 2 may leave them without much.
So that's what I want to be very clear. The exact relief, saying the state of Maine is violating our constitutional rights, is available under count 1. If the
The
court
tricky
were to-
part is the remedy, and that isn't even available anyway on a count 5 DJA.
Correct. That underscores the fact that the DJA isn't an independent cause of action. You can get the relief saying that the state of Maine has failed to comport with the Constitution when the state officials have violated it, or either through their affirmative actions or through their omissions, if they're the ones responsible for complying with the Constitution. I do want to make the point that this would be a very different case if the state was standing here saying that there would be no way to obtain this relief, which was the case in some of the foreign state cases that plaintiffs cited. Here, they can obtain declaratory relief that runs against the state, and the state is not stepping in the way of that. What does become a problem is the plaintiffs grouping together the entire state government, asking what the state's position is, for example, on the Sixth Amendment, and understanding what that means. Does that mean the state judiciary's position on the Sixth Amendment, the legislature, or the executive? The governor, as was pointed out earlier, and the AG were both dismissed under the doctrine of sovereign immunity. It is unclear how they would.
The governor was dismissed in this case? The AG was. Was the governor also was a?
I apologize. The AG was dismissed. The governor, the court did not permit a count to go forward against the governor in the amended complaint. Thank you.
Was the AG dismissed on the ground of sovereign immunity?
I thought it was more standing.
I apologize, Your Honor, if I misspoke. I thought sovereign immunity was one of the defenses that was raised, and the court issued something along those lines, and I apologize if I'm inaccurate in that.
Thank you, counsel.
Thank you, Your Honors.
Once more, as is our usual practice, we will be taking this matter under advisement and issuing a written decision in due course. And with that, we will be in recess on this matter. Thank you. Good morning. You can be seated. The matter before the court is Cumberland 25-196, which is Robert Hutchinson versus Rosanna Paola de Cordoba Gomez, I assume. I'm not sure if it goes by Cordoba Gomez. We are being streamed live on the web. It is both by video and by audio. I would ask counsel who will be arguing in this matter to introduce themselves by saying their names for the record, together with the party you represent, starting with the appellant.
Jonathan Dunitz on behalf of Rosanna Paola Cordoba Gomez.
Michael Sir here representing Robert J. Hutchinson.
Thank you. And Attorney Dunitz, if you're ready to proceed, we'd be happy to hear your argument this morning.
May it please the court. Jonathan Dunitz of Verrill Dana on behalf of Rosanna Paola Cordoba Gomez. With me at counsel table is my colleague, Michael Donlin. This divorce appeal involves two overarching issues. First, the lower court's interpretation of the parties' premarital agreement, and second, its decision regarding Rosanna's request for attorney's fees. The interpretation of the premarital agreement, in turn, has two subparts. One dealing with Roby Hutchinson's commitment to establish and pay for a marital residence, and second, the allocation of property that Roby acquired after the marriage. Rosanna is not in the courtroom with us today. She wants me to assure the court that she takes this matter seriously, but she was forced to return to Columbia because of the financial and emotional impact of the lower court's decision in this matter. Rosanna moved to the United States from Columbia to marry Roby. In making that decision, she was forced to forfeit her legal career because her legal training took place in her native Columbia. Recognizing the isolation and financial difficulty she would face should she and Robbie get divorced, she was willing to sign a premarital agreement only if it included provisions that would avoid her being impoverished in the event of divorce. To that end, the provision requiring that Roby purchase the Chandler's Wharf condominium and make it marital property was a material term of the premarital agreement. When the premarital agreement is viewed as a whole and full effect is given to its language, it is clear that the parties' intention was to include the value of the condominium in the marital estate. And because Roby was going to purchase it with his own money, it would not be subject to any loans. The court added confusion to this issue by simultaneously interpreting the provision while also finding that it lacked jurisdiction over whether the failure to purchase the condominium was a breach of the premarital contract. Moreover, the court determining that it did not have jurisdiction to enforce a provision in the marital agreement creates the proverbial slippery slope by opening the door to parties finding creative ways to bifurcate marital dissolution matters into divorce cases and contract enforcement cases. This is contrary to this court's admonition that courts seek to avoid decisions in divorce actions that do not completely resolve the dispute between the parties and fully dissolve the relationship. The court also erred by improperly expanding the marital property waivers beyond those agreed to in the premarital agreement. By expanding the waivers to property acquired by Roby after the marriage that were not Hutchinson family businesses, the court ignored that waivers of statutorily protected marital rights must be clear and unmistakable. The premarital agreement only clearly and unmistakably waived post-marital acquired property interests if they were acquired as part of a Hutchinson family business. All other post-marriage acquisitions by Roby should have been presumed marital and equitably distributed. Finally, the court's basis for determining that the legal fees were excessive and unjust was an abuse of discretion. The court limited Rosanna's fee recovery.
Well, I see that the green light is on. Let's take up that issue with the attorney's fees. I mean, is there any of the factors that the court pointed to? I understand you think that he didn't weigh it properly, but are any of the factors improper factors?
The factors were not improper factors, but the court erred when it found that Rosanna spent a considerable amount of time challenging the validity of the agreement.
Well, it made that finding in conjunction with a finding essentially that this case was over-litigated, right? I mean, that both sides spent, frankly, too much time litigating this case.
It did that, but that was also somewhat of an error in judgment. The record shows that Roby over-litigated this case, fought with Rosanna.
Is that really the
discovery.
issue, that it didn't give appropriate deference or appropriate consideration to the fact that Mr. Hutchinson also over-litigated the case? If it's gonna
Mr.
find that?
Hutchinson is far more able to litigate the case than Rosanna was, and she was essentially left destitute by the decision and by the court's interpretation of the agreement.
Were any attorney's fees distributed prior to the final hearing other than the $10,500 penalty?
There were no, before that, there was a motion pending that was never decided. It was filed early in the case and was ultimately not decided, so there were no legal fees distributed prior to the final decision in this case.
Did the court have the benefit of Mr. Hutchinson's legal fees in this case? Sometimes it's useful to see what both sides incurred.
I know that Mr. Hutchinson offered to provide them. I do not recall whether they were actually provided by Mr. Hutchinson.
But you agree that the attorney's fees award is a matter that is committed to the sound discretion of the trial court, and the burden on someone challenging that would be to convince us that there was an abuse of discretion there?
We do agree with that, Justice Meade, but we do believe that it was clearly erroneous and abuse of discretion because of the finding that much of the legal fees went to disputing the validity of the premarital agreement, when in fact, long before the first actual hearing in this case, Rosanna stipulated to the validity of that agreement. Much of the effort in this case went to the enforceability of the case.
Well, everybody agreed there was an agreement here, and the agreement's on paper. That's the case. But let's dive into the agreement. It seems to me there are two parts to this that are actually kind of separate. One is protection of what would otherwise be marital property. Another is the condo issue. I'd like to address those separately, if we could.
Yes, Your Honor.
Looking at the agreement as a whole, as you say, which is what we must do, we must look at the four corners to discern the intentions of the parties, and that's what the trial court did below, but we conduct our own review. And as I look at it, it seems to me that what is happening here is obviously Roby is bringing a substantial amount of assets into the circumstances and anticipated acquiring more and all the rest of it. And I do note at the outset when the sort of the overarching theme of the parties is that both parties acknowledge that it is their intention that the personal investment, partnerships, corporations, and other business entities in which the party may have an interest now or may obtain in the future should not be liquidated in any way or disturbed as a result of the marriage here. That seems to be the theme that's following there, and I note that you have picked out specific sentences or paragraphs here that may suggest that maybe it's not as airtight as it seems, and there may be a way to access these points.
That is correct, Your Honor. It is not as airtight as one would suggest. In Section 7, there's you can distinguish between the opening paragraph that talks about Roby's property, and then a later paragraph that says Roby and his family intend to be involved in other businesses and interest in the future as partners and shareholders and officers. It's Roby's expectation that he may actively be involved in these ventures, and these may become valuable assets and increase his net worth and his income. Such business interests subsequent to the date of marriage are specifically designated as Roby's sole and separate property. That paragraph's talking about family businesses. So to the extent that Roby is involved with his family, with businesses that his family, which they have a long history, for example, Lexington Gardens.
So what do we, obviously you're going to anticipate this question, but in the lead-off sentence, is the President Roby owns or has an interest in businesses including, but not limited to, so they name off some principal businesses there, but it is not limited to those, it's not limited to them literally. Then it talks about he expects to get some more. So the first two paragraphs are talking about Roby's business circumstances, and then you get the penultimate sentence in the third paragraph, which is, such business interests subsequent to the date of the marriage are specifically designated as Roby's sole and separate property, including but not limited to the increase in the value, basically making all of this stuff non-marital property. So if you read the entire Section 7, lists the businesses, what may happen in the future, but all of this stuff is rolled into one mass that is not going to be part of the marital estate.
But there, in that paragraph, there are two different, the first section talks specifically about Roby's property.
Right.
The second or third paragraph then talks about Roby's family property. And it is in that paragraph where you find that, that those business interests are set aside to Roby. It doesn't talk about future business interests that Roby gets personally.
So is it your position that if the word "such" started a new paragraph, then all the preceding business interests and references would be included?
I think that's, I think it's possible. I mean, in interpreting an agreement with a different paragraph, I'd have to see how it works, but I think
But your argument, if I hear your argument, it is that because that sentence is included in the paragraph that talks about specific business ventures and interests of the family, that it's limited to that.
Yes.
I do, in this short time you have remaining, I do want to get into the condo issue, because I think that is nuanced, and so I want to review it. As you know, part of the agreement said that he intended to acquire his mother's condo. Apparently she was in ill health, it was anticipated. And this is before they're even married. They're still in that premarital lovey-dovey state. And you know, down the road, we'll have our nest here. I'm going to get that condo. And by the way, this condo will not be subject, you know, to this stuff here. If we get divorced, you're going to get a big cut of this condo coming down the road. That's how he was feeling at the time. And it appears that things kind of got rocky at some point. They moved to New York, and then they were living separately. And at some point, not clear, it was no longer his intent to create this love nest, and he never did acquire the property. What my concern here is it's black letter law that if parties to a marriage and parties to a divorce have a business relationship, a contractual relationship with a third party, the divorce court has no jurisdiction to handle that thing because the third party there gets put off to a contract action, separate contract. But in this case, neither one of the parties had an interest in the condo. It was a matter of the estate. So it turns on whether or not, as you've posted it, that as part of the divorce here, that she would be entitled to something because he never acquired the condo. Is that correct?
That's correct, Your Honor.
And so the court made its decision down below saying an intent to do something in the future is not a shall, or it's not a will, all the rest of it, and sort of nixed that. And we'll have to look at that issue too. But then the court suggested that there may be a separate independent contract action, which doesn't seem to follow, because the court, if you won on your point that there was a promise there and she gets some benefit of it, then you would have gotten it as part of the divorce. But there doesn't seem to be a separate independent cause of action. You were concerned that it may be a res judicata issue. So in the 50 seconds remaining, I'd like you to address the fact, you know, what is left here. If we decide that, you know, I intend to do something, doesn't create a contract, that's probably the end of the road, isn't it?
There is a pending, we followed the court's advice, and there is a pending case in Superior Court for breach of contract.
And it gets complicated because the divorce court said without prejudice, which means it sort of implies you can start all over.
Correct. So it's complicated because the court said they don't have jurisdiction, but then interpreted it. And so how that applies, but again, that's part of this confusion that's created by this decision by saying, I don't have jurisdiction, here's how it's interpreted, go bring it somewhere else. But that also creates a slippery slope of parties could then find creative ways to carve out pieces to go to Superior Court. I see that my time has expired.
You'll have another opportunity. You'll have a couple minutes that you reserved. Attorney Saucier.
Chief Justice Stanfield, members of the court, it's a privilege to be with you again. We see this case as one involving a decision made by an experienced district court judge following the rules of construction that are set out by him, by both parties, that essentially require the entire contract to be looked at, things not taken out of context, and the meaning of the agreement considered. With respect to this particular premarital agreement, it's our position that the court did what needed to be done to enforce a premarital agreement that essentially said, you have your property, and I won't interfere with that. I have mine, and nothing that I have will be given to you based on the fact that we were married. Those are solid legal bases, judgments made by the court, and I think that they stand. The abuse of discretion we can speak to later, but with respect to the premarital agreement, we see this as one that has all the hallmarks of a standard, valid premarital agreement. It has full disclosure of assets. It has independent counsel on both sides. It was agreed to based on a full knowledge of the other party's financial situation. And it was made without fraud, duress, or misrepresentation. The suggestion of destitution is something that is new at this level of the proceeding. There was no basis for the court below to find that, but the court did make findings with respect to particular aspects of this, and those aspects include the fact that there was an effective waiver of equitable distribution, the fact that Mr. Hutchinson had business interests, he had family interests, and that he intended to pursue those. And I think that is clear throughout the document, including at least some of the points that Justice Meade made with counsel in his colloquy. We don't believe that there was an error here.
Counsel, I see that the green light is on. Can we go particularly to paragraph 14 with regard to the condominium? As you know, I think general contract law, you know, you read the agreement as a whole. I'm looking at this paragraph, and although the second sentence says that he intends to purchase a condominium at 403 Chandler's Wharf, Portland, and that was the language the court below focused on, I'm looking at these two paragraphs as a whole, and it seems to me that the parties have very clearly thought out exactly what's going to happen. He will purchase the condominium. He's going to purchase it with his own funds. It's going to be sometime around 2016. They expect to live there, and indeed they did live there for a period of time, although not later. And it shall be titled in joint names as joint tenants. In the event of divorce, the value shall be divided equally. He actually shall acquire it in the divorce, and that neither party will encumber it. And isn't that far more than precatory language? I mean, it's clearly well thought out and isn't taking the whole agreement, particularly if you are right and the court below is right with regard to the waiver on all the other interests. Isn't this essentially the quid pro quo for those waivers, that you're going to get a couple of $100,000 in the event of a divorce out of what was a residence, what we anticipate a residence, and we've specified that that's what you're going to get by not purchasing it. He's trying to say, oh, sorry, too bad.
Chief Stanfill, I think that what the court did below was to look at two precatory phrases, and those are key to what was going to happen.
What's the second precatory phrase other than intends to purchase?
Intends expected. So there was an expected purchase in 2016.
Show me that. I'm not seeing that. You
Fifth
mean
line.
the sentence, will purchase it with his own funds, i.e. not mortgaged, sometime around 2016? Is that what you're talking about?
The purchase is expected in 2016, yes. It's that
Okay, that phrase
parenthetical, yeah.
at the end of the sentence, okay.
Yeah. So the court looked at those two phrases as precatory, no mandatory purchase.
And I understand that's what the court did. Don't we get to look at this agreement and decide whether the court was correct? And it said it was unambiguous, right?
The court said it was unambiguous, correct.
Okay, so we will look at the agreement of the whole and determine whether it's ambiguous at least, or perhaps unambiguous the other direction.
Those are your alternatives, yes.
Okay. What is the consequence if we say it's a fact question?
A rehearing, I would expect, on that issue of intent. And from the testimony we had at the hearings on October and December, there will be evidence that shows intents or goals changed with these two couples. As they say,
Once they got out of the lovey-dovey stage, as Justice Meade called it?
to use the technical legal terms, yes. I was thinking more of premarital agreements are written in ink, but marriages and lives are lived in pencil. And that's what these two did. There was a change in desire, both in terms of living in Maine and
I
pursuing
understand
a
that,
career in Maine.
but the judge decided below that as a matter of law, this paragraph essentially created no marital property interest, or even putting it another way, since it wasn't ever purchased, at least some consideration in the distribution and in the compensation or equitable distribution or an equalization payment, shall we say, that the court made. I mean, it was just like, we were not even going to consider this paragraph, right?
Well, I think the two instances that you point out later in Section 14, the judge considered and
At the divorce hearing or at the, just in interpreting the premarital agreement in the earlier order?
in the earlier order,
Okay.
yes.
Which was a non-evidentiary hearing, is that correct?
Right,
I
yeah.
mean, I know there were some stipulations, but,
Stipulations, not evidentiary. The plaintiff attempted to call Attorney Abramson. That was objected to, and the court sustained the objection. So that evidence didn't appear. But
Counsel, what was the purpose of paragraph 14? And I say that in the context of your comment about agreements are written in ink, but lives are lived in pencil. But at the time the agreement is entered into, there are certain rights that are being given up, surrendered. And so why shouldn't, so let me come back with that in mind. What was the purpose of paragraph 14? Why is it there?
to set out a goal, I would say, and certainly that's what
Was there a
court-
reliance on that?
I'm sorry?
Was there reliance on that in the contract?
Not at all, because the arc of this marriage had more to do with Rosanna pursuing a career in fashion, education in fashion, and that was supported by the plaintiff. The two points that the Chief Justice raised with respect to language later in Section 14
think there were more
found
than
to be,
two.
and we believe they were directives in the event the goal was achieved. And that's the way I think the court interpreted it, and that's the way we think is the correct way to interpret
This
it.
condominium is currently still held by Mr. Hutchinson's mother's estate, is that correct? Or at least it was at the time the appeal was filed in this record?
Yes, at the time of the
Yeah, we don't really consider what may have happened since then.
2025.
Had other assets from that estate had already been distributed, though, to Mr. Hutchinson, right?
There was no evidence taken on that, Your Honor.
I thought Lexington Gardens was acquired by
Oh, okay.
inheritance.
Well, and that was subject to testimony, certainly. But with respect to the condo,
I know the condo wasn't, but I
Yeah.
mean, he had, so is there some control in his part as to whether the condo had been distributed to him or not? I mean, maybe that's just unanswerable on the record.
I think unanswerable on the record, he's not the only sibling, or
Okay.
he does have a sibling, and I don't know, I don't have any details.
At the time of the divorce, the condo was held by the estate. I'm wondering what the district court judge would have done with the claim that if the court believed that it said shall purchase or will purchase, but the purchase didn't take place, would the court order him to buy it? Or would there be some complicated expert testimony saying, well, it could have been purchased for this amount, and then use that as the formula to address how it gets divided? I'm just wondering, what would the court do with that circumstance at the trial level?
I think the court would have to take evidence with respect to value at the time.
Well, the value at the time wouldn't matter, for it was the value at the time of divorce, which I understand other provisions may have defined earlier than the actual date of the divorce
Yeah.
judgment.
Yes, that's right, Your Honor. But one of the issues that we raised below was proving damages, and that was not done. And
But the court had precluded it as an issue. I mean, obviously, there's no reason to put in evidence on an issue the court said you can't.
But our point, Your Honor, was that the evidence that was going to be presented would have been largely speculative.
I'm sorry, I couldn't hear you.
Would have been largely speculative
The value of the condo would be speculative?
in the absence of any significant showing of value, interest rates, how much money was going to be put down, the amount
Well,
of
said he would purchase it with his own funds.
But if there was, would there have been a mortgage on this purchase? I mean, if
That was,
if the condo is going to go to
there
1
was a
point,
specific reference to a mortgage in the
if the condo had a value, fair market value of 1.5 million at the time, back in whenever, but it was also mortgaged to the extent of, 1.4 million, the equity to be divided. In that instance, would be one thing, or if he bought it for cash, that'd be an entirely different thing. How would we know how that was going to go back in the day if he did in fact acquire it?
Well, the court would need to take evidence, certainly, yes. But
But we don't, how can the court ever know what the amount of the mortgage would have been?
that was our point exactly.
Well, that's what I'm asking you.
Yeah, yeah. The court would not. The court would not.
Does, the property was not acquired, I mean, that's the reality, but does that, if the court thought that this provision still had some meaning, shouldn't the court at least account for it in somehow in the equitable distribution? In other words, even if it's not strictly a valuation, remember, equitable distribution doesn't have to always be 50%. Should it at least have been accounted for that there was an if there was an expectation that there would be some distribution from the condo?
I think
You may answer.
With respect to a short answer, the court was struggling with the fact that whoever was going to own it had not appeared, at least by the 2023 hearing or by the hearings in late 2024. So there was nothing for the court to decide, really.
Thank you. Attorney Donis?
Just briefly, Your Honors. In fact, it would be a fact. If there was a rehearing, if you found that it was ambiguous, there would be a rehearing to take.
Is it ambiguous, or is it your position that it clearly created a essentially contractual right, or something that wasn't carried out but should still be accounted for in the equitable distribution?
It is our position that it's unambiguous and it should have been carried out, and that it could be distributed and determined by the court below. However, if it was ambiguous, there was never any evidence taken on what each party's intent.
And even if it's not ambiguous the other way, this still has to be rehearing because you were essentially precluded from putting in that evidence?
Correct, Your Honor.
But how would you calculate what the amount of the mortgage would be?
As Chief Justice Stanfield said, the agreement was that he would purchase it with his own funds. And so there would not have been a mortgage. And then the definition, the distribution was the net value of the marital residence defined as the fair market value less any first mortgage and other liens or encumbrances. But to the extent that there needed to be any encumbrances on it, the parties had to agree to it. So that he had to buy it with his own money, so there would not have been a mortgage. And so
neither party shall encumber it with a second mortgage. Home
Yeah.
equity crimes of let it.
It doesn't say first mortgage in that provision.
But it also does say that he's going to purchase it with his own
Well,
funds.
he can use his own, well, we can argue this till the cows come home. We can purchase it with his equity and get a huge mortgage on the property.
And in addition, as far as the business interests go, I just want to touch on that briefly, because in the record, he testified that he deposited money from his own account, or from Lexington Gardens into his own personal bank account, and then used that for other purposes. So we would argue that that creates marital property. Thank you.
Thank you. Thank you, counsel. As is our usual practice, we will be taking this matter under advisement, issuing a written decision in due course. Thank you.
All rise.
morning. You can be seated. The matter before the court now is York 25-269, Constance Beane versus the Village on Great Brook. I see counsel are present. I'm assuming ready to proceed. We are being streamed live on the web, both by audio and by video. I would ask that before we begin the argument, counsel identify yourselves by saying your names for the record, together with the party you represent.
Good morning, Your Honor, members of the court. My name is Patrick Bedard. I represent the plaintiff, Constance L. Beane.
Good morning, Your Honor. May it please the court. My name is Benjamin Ford. I represent Appellee's Village on Great Brook, LLC.
Thank you. And Attorney Bedard, if you're ready to proceed, we'd be happy to hear your argument.
Thank you. Madam Chief Justice, members of the court, good morning. My name is Patrick Bedard. I represent Constance Beane. This is a fairly straightforward case, and it involves whether or not a condition precedent in a contract, the requirement in this contract, which both parties here signed, the requirement that planning board approval from the town of Elliott be obtained. If it was not obtained on March 1st, 2023, but was obtained, I believe, on March 28, 2023, whether the failure to obtain it for almost 4 weeks breaches the condition precedent, or so to speak, condition precedent is not met, so the contract is no longer applicable.
Whether time was of the essence, correct?
Nowhere in the contract does it indicate time was of the essence.
And we have said there need not be any magic words, correct?
Correct, and I think I quoted the case that said you look at analyze the type of contract it is, to try to determine is time really of the essence. I think the Associated Builders case talks about the materiality of a breach, which kind of feeds into that and the idea.
Even when there's an express term that requires performance by a certain date?
Yes.
That was not the case in the Associated Contractors case, was it?
It required it by March 1st. So the question is whether that was material.
If it wasn't material, why was it in the contract?
So you can have a provision in that is important, but it's not necessarily material to the deal.
It's an express term in the contract.
And it can be in this situation where the Elliott Planning Board did approve this almost 4 weeks later, it can still satisfy the terms of the contract. I agree that Elliott Planning Board had to approve this, and that was material.
But then why put a date? Why put a date? As far as I can tell, this had been pending for quite some time, in fact, in front of the planning board. I mean, but why put a date if that's not material? And why not? Certainly it needed to be approved in order for Village on Great Brook to proceed with all of the other obligations, but there's a date.
Yes, and I can't speak to that. I wasn't part of the negotiating of the contract, but some people put in dates to motivate parties to get them to move as quickly as possible. It's sometimes better than as soon as possible or with all
Just because you have a date in it doesn't mean the date is material or there's action contingent upon that date. They do it in construction contracts all the time, correct?
Yes. And I think that's really the question, is the gap of little less than 4 weeks material? And I have other arguments beyond that, but I don't believe it is.
I know this is sort of extrajudicial, but what was the point? The contract, the agreement was signed on February 13th, or was dated February 13th. The performance requested was literally 2 weeks later. What was the point of putting that in there?
I only can believe that it was to motivate people to move quickly, and I agree that probably the attorneys, both sides drafting this, neither attorneys, I think, were the party attorneys involved here, but I expect both attorneys should have noticed that and realized we're going to get a bunch of unit owner signature, we're going to date this, it's too soon, we need to extend it out. I see those as motivation dates.
Was anybody prejudiced by the fact that the planning board did not approve it until March 27th?
I don't believe so, and as you've seen me argue, my client had no control over those when it was approved. I called
But neither did the Village on Great Brook, right?
They may have, and that would have to be something developed with testimony. I'll refer to them as VGB for sure, but two people have the control. The applicant, do you submit your material? Do you do what the planning board needs? And usually there's an iterative process. And then how quickly can the planning board meet and decide this? And that sometimes is a matter of scheduling. And those of us who have dealt with administrative proceedings know it can take some time. it's highly unlikely any unit owner could control this. I mean, there would need to be evidence that unit owners actually tried to obstruct this, tried to delay it, and did something to delay. That would have to be developed on record evidence. It might be, and I doubt it, but if it ever was, that would be an argument VGB could make, that it was material, you obstructed it, you had control over it. Otherwise, this is a weird condition precedent in that the timing of it.
But doesn't the restatement suggest that a temporal condition can be material?
It can be. It can be material, and it also suggests that it's not necessarily material. Use the words time is not of the essence as the opposite of sometimes the timing of these doesn't matter. And then it talked about an example. I realize that example was 1 day late in performing, but the same idea can be present here. It can be that it does not really matter, or it's not that important. And it gets then into this disproportionate forfeiture.
Your point is not necessarily that it's immaterial, it's just we don't know at this stage, and it's a question of fact. Is that
right?
Do I have that right?
Yeah, it's an affirmative defense, and the burden's on the defendant to prove it. It's not clear from just the contract alone it's material, and that the court should just dismiss it because it wasn't met for almost 4 weeks.
What do we do about the Colbath case, which VGB relies on, where we, at least in that case, seem to suggest that the timing provision was material as a matter of law based on the language of the agreement?
So
how would you distinguish that?
Yeah, and I read it all yesterday, and I'm going to guess that that's the one that I spent more time on the end on, but I'm looking really quickly to see.
It's the logging case. Yeah.
Perhaps one basis is because it was an action at law. And when you're asking for specific performance, that's an action at equity. And time is not generally deemed in equity to be of the essence in a contract. And that would be Story on equity. So perhaps that's the distinguishing feature of Colby. And so then we're drawn to more recent language in our contract law that says there are no magic words. We must look at context. That's a softball.
Yeah, your answer is yes.
Yes. As I'm looking, yes, I think that's true. There is a distinction. I understand the equity in the law.
Well, and the other problem is that our prior cases where we've really done that about a condition precedent, ordinarily it's the person who's trying to get the other party to perform is also the party that didn't do something in a timely fashion. Now I'm not going to remember which case name is which, but the one where, wanted to extend the lease and tried to do it too late, or right. That's not what happened here. And it would be an odd, if in fact VGB had any control over when this was issued, it would be an odd result indeed that one could essentially vitiate the contract by not performing an obligation by a certain date.
I agree, and that was the key case that I spent time on, which is you let the landlord know within 30 days prior to the expiration of a lease you're going to renew it. I think it was a 5-year renewal. Right. That's clearly a reliance argument, didn't exist here, and I agree with that. I mean, I found Colbath. I underlined the part of Colbath where I think distinguishes it. It basically told the lower court judge whether the parties intended time to be the essence was a question of fact for them to determine, which tells you if it's really a question of fact, it's not a 12b6 motion. I don't dispute for a moment that VGB can argue somehow this is material, there's a breach of the condition precedent, you didn't meet it in time. But not on a 12b6 motion. It's not obvious the affirmative defense wins and the case is over. That's my point. It's not material. There's nothing in here to indicate it's material. And there's also the disproportionate forfeiture cases. Some of the ones I quoted, like the employee who didn't return probably a computer and a couple of things was denied $2.6 million. And a court said we're not going to enforce that. Although it's a condition precedent to paying the employee, if you didn't return some items, that's disproportionate forfeiture. Similar on these, I think it was Burger King, you got enough restaurants going, you didn't meet it exactly, but you were close.
On a side note, I don't even know if it's before us, but what, if anything, would we make of the letter of April 18th? Is that a factor for us to consider at this juncture? Or do we get into whether or not there was a waiver or a settlement negotiation? Do we even reach that?
I don't think you do if you believe or think my argument on materiality and disproportionate forfeiture are correct. that this wasn't a material, or maybe it is a material breach, but it's going to have to be factually
So if
developed
it's a
on
fact question, then that sort of dances around whether, the reconsideration was appropriate, and the letter will be considered in due course for whatever it's worth.
I think I'm still allowed to amend the complaint if this goes back. I certainly would, just to add that as a waiver argument. But I think only if the court says it's material and we don't believe your disproportionate forfeiture argument, we think the judge was right on that, then you get to the next one, which is the waiver argument, which is kind of ironic. Waivers are an affirmative defense, so I'm bringing an affirmative defense against an affirmative defense. But this idea that it's waived, and I think it's very clear from the letter, the judge characterized it as a negotiation, but this lawyer says, listen, we've
Well,
got
and whether or
beyond.
not it's waived, it may go to the issue of whether it really was very material.
I think I look at it that way. You see the letter, he just quickly, they bypassed this. Why, fine, we got to the planning board, things obstructed us, who knows what really happened.
Counsel,
let's talk about 12D, which means the contract's still in.
I know that standing was addressed below, and it's not an issue before us today, but this is an agreement basically between the unit owners. It's not the Unit Owners Association, or was it the unit owners individually and collectively?
I think it was the unit owners individually. It was also the association, where two parties on one side. The ironic part is VGB at that time, I think, controlled the association, so essentially was contracting with itself. Unit owners got in there, and they could have done two separate contracts. I'll acknowledge, I probably should not acknowledge this on the record, but the standing argument seemed much more interesting to me. I'm surprised the condition precedent got this far. Standing argument was very interesting, because I knew from the law court decisions, condominium associations, nonprofits, there's no, you can't bring an action as a member. That's not allowed like in a business corporation. So what I ended up doing was looking at Delaware had better cases, seemed to suggest that if both parties, a corporation and a shareholder or unit owner, somebody had an interest in the corporation, sued to enforce a contract everybody signed, the real key was whether the unit owner, in this case the unit owner, or the shareholder could show separate harm other than the association or other than the corporation harm. I think we can meet that. And I think that was the key in the cases I started drilling into. And I think that, along with the zoning cases, it says if this happens near you, you have standing, that kind of idea. So the court did approve that, and I think the court was right to do it. But that was a more interesting argument to me, and I still think they're standing. I think she's right next to this. She can show she's different from all other unit owners. But you're right.
No other unit owner has joined in this suit. Was the contract, and again, this may be extrajudicial, but was it fully performed?
Those are good questions, Judge, and I don't have a complete answer. Without going too extrajudicial and going off, there is a separate lawsuit, and that's in a different court, and there's apparently a previous contract I didn't even know about between VGB and my client and I think her husband when he was alive. So there's other issues going on here that I think we can't get into that. I don't know what really happened here. I believe everything was performed. I've talked to a board member and Connie Beane. I believe parties performed and went forward, and I haven't heard anything differently. But I expect if that's continued to be brought up, we'll get to the bottom of it. But I believe it was. I know the most important thing for VGB happened, and that was they got their planning board approval. I mean, that's the key. You can see that from the agreement. Back down, let us get our approval because you're stopping us. We want to be able to get this approved. That's the key. It happened. After that, most of it looked like a negotiation on 12D, and I think they got what they wanted, and they're not performing their end. So, thank you.
Thank you. Attorney Ford.
Good morning, Your Honors. May it please the court.
Isn't it a fact question, since you decided to let the green light come on right away, as to the materiality of the date? In other words, clearly, getting that approval is necessary. But the date? Why does it matter whether it's March 1st or March 28th? And there may be more than one answer to that, but then doesn't that mean it's a fact question?
The answer is it is a fact question. But it's also a question of law. And Justice Connors, your analysis of between it being a legal issue or equity issue, I think is an interesting one, because ultimately when it comes down to it is if the parties go through the trouble of putting a date into a contract, a date certain, then I think Colbath and the cases after Colbath all say that this court and any court has to honor that. We don't get to look into the motivations of the people.
Let me quote another Maine case. An express stipulation in the contract that time shall be of the essence of the agreement will not be accepted by a court of equity as a final and conclusive determination of the question of specific performance against the manifest equity disclosed by all the facts and circumstances of the case. Telegraphone Corp. versus Canadian Telephone Co., 103 ME 444, 1908.
Sure. So we're looking into all the facts and all the circumstances, but are we looking into the facts and circumstances when the language itself is not ambiguous? The language in the contract clearly states that the duties do not arise under this contract. Neither VGB's duties nor Ms. Beane's duties arise unless there has been approval before that date. So because the information and because the language in the contract is not ambiguous, it is not up to us
So
to
you're
look into
saying
the
there are
parties'
magic words in this contract
The
that make
magic
it,
word, excuse me, Your Honor, I didn't mean to speak over you.
that make it, even though we have said that you don't have any magic words for time of the essence in Maine.
The magic words being time is of the essence is not.
Oh,
is
there
not
are
something
other
that's required.
magic words.
Yes, there are, Your Honor. Here, you ready? Here's the magic word. March 1st, 2023. That's the magic word.
The date, it's the magic word?
Yes, Your Honor. Because the cases leading up to this point all say that if the parties go through the trouble of stating a date, there's a reason why we do it.
What are we to make of the April 18th letter?
Yeah.
And the statement that VGB is willing to waive the March 1 deadline?
Sure. Before we get into the April 18th letter, the first question we have to ask is could this letter have been produced? There's a case law that says that on a motion to amend the complaint or a motion to amend the judgment, the first question we have to ask is not what's in the letter, but could this have been brought?
That's the motion to amend, not really the complaint.
Excuse me, motion to amend, yeah.
Reconsider.
But okay, so setting aside those issues, what are we to make of it is exactly what the trial court made of it, which is if you read the text of the letter, it's an offer to negotiate. It's an offer to move forward, given that the duties of the parties never arose in the first place.
Well, that's one interpretation of it, but that seems to me to be sort of inferring a lot. You think the letter is that clear as to what it means?
Actually, the letter has to be much more clear in order for it to rise above, in order to meet the threshold to be a waiver of.
But even if it's not a waiver, could it be evidence? I understand you're saying it was really an offer to settle and therefore, but I mean, even if it's not an actual waiver, is it not evidence that maybe the date wasn't so important after all?
I don't think it is evidence that the date wasn't important after all. That's because if you look at the text, if you look at if we're going down this road, we're going down this road for argument purposes. I don't think we need to be here, but we're here, so let's talk about it. It's not a waiver, and it's not evidence that we didn't. It's not evidence of immateriality because the context of the letter is that none of the obligations that we created for ourselves under this contract.
So not as a matter of law, but isn't it at least facty?
I don't know that it opens
to adopt someone else's word.
Sorry, Judge, I didn't mean to talk over you. I don't know that it opens any doors that haven't already been closed.
So is it your position that if you got the approval the day after the date in the agreement, same result?
I think in that situation, Your Honor, then Ms. Beane and the plaintiffs would have a disproportionate breach argument. But that's not what happened. The approval happened several weeks afterwards. And
but who was prejudiced by that?
So I was just going to get to that point. So again, we shouldn't be talking about who's prejudiced and who wasn't. But what we can say is, if the facts were to develop in this case, what you'd find is that the plaintiffs in this case did not perform under the contract. That's not in the pleadings.
Sorry. What about the fact that some of the parties to this contract didn't even execute it until after March 1st. I mean, we've got people signing on April 3rd and March 16th.
That's exactly right, Your Honor. And I think that that is a fact that cuts into our favor onto the merits of the case. Because remember, the other condition in the contract, in order for the duties to arise, would be all of the parties have to sign on to this agreement. And at
So you're
that
saying
point,
they never did it?
they hadn't signed on to the agreement.
So, because I mean, what's interesting about this contract is it really doesn't impose any obligations to do anything, right, on the plaintiffs. It's if basically, or on the unit owners, it's basically if, you know, your client does X, Y, and Z, then they will waive their claim, you know, they will consider their claim satisfied essentially, and all other claims are waived.
Respectfully, I see it differently. The issue leading up to, again, we shouldn't be talking about this, but the issues leading up to the contract were that some of these unit owners were putting up roadblocks and opposition to get these permits passed. And so what this was an agreement that the unit owners would basically stand down and allow the planning board of the town to do its job so that VGB and the developer can actually go in and address the issues that the unit owners had. So in order for the
Paragraph 7, each unit owner agrees not to express any form of opposition to approval of the obligation or to disparage the project.
That's correct. Yeah, that's correct.
But other than that, all they're really doing is just basically agreeing to stand down and then releasing any claims as long as VGB performs.
Yeah, and that, you know, the standing down and releasing claims, I mean, that had honor, or that had value, but in
And so
order
now, under your position, those claims are not released and they can have any opposition they want.
And they could after the first, absolutely. I mean, they were free to speak up and oppose the project all they wanted, because it wasn't just VGB that was released from their obligations under the contract after that date. It was everybody. Not released, it was just the obligations under the contract never arose.
Well, did VGB get the benefit of the bargain, so to speak? Did they get what they bargained for in this contract?
The answer to that is no.
Why?
Because there was still other oppositions going on, there were still other things, and not all of the unit owners had signed on to this at that point.
This is sounding awfully facty, though.
It is, and that's why we shouldn't be talking about it, Your Honor. The reason why is none of these facts were pled in the complaint. They're just not there. And
But
so,
whether or not they're pled in the complaint doesn't really matter. I mean, what matters is whether there's a cause of action pled and whether, as a matter of law, one can say that the March 1 date means the contract's off.
respectfully, there has to be enough for us to grab onto here. There has to be enough for us to imply facts that would allow them to win their case. And all of the facts that we've been discussing here are not, they have not been mentioned. They're not discussed and they're not pled.
What else did VGB not, what did they not obtain as a result of this contract that they expected to?
I don't have a list, a comprehensive list of that, Your Honor.
Was the non-resistance specific to this application, though?
Yes.
And the application was approved?
It was approved,
So
yes.
VGB then reaped the benefit of the bargain, didn't it?
Respectfully, we don't know if it was approved because the town was going to approve it anyway. We don't know if it was approved because enough people...
Does that matter, though? Does that matter?
No, and in fact, it doesn't matter. But ultimately, what happened was the VGB did not get everybody to sign off on this agreement. They did not get all the claims released, and they did not get their approval by the date
That sounds
that they
like
had
a summary
bargained for.
judgment argument, not a motion to dismiss argument.
Sure, but in a summary judgment, you have a record. You have a record that's developed. It's before the court.
And that's the problem. We don't hear.
We don't have
But
it.
we do, respectfully, Your Honors, we absolutely do. We have before you is a complaint with facts, and you are allowed, and we're all required to imply those facts to the maximum benefit of the plaintiff in this case.
Can we go back to Justice Connor's hypothetical about what if the approval had come the day after? And you said, well, then maybe it would be disproportionate. So where's the line? I mean, we have 3 weeks here. You're suggesting, well, that's far enough that there's no disproportionality. How are we to assess that just on this sort of bare bones complaint that we have?
I think that you would, in that situation, and again, we're getting into facts, but in that situation, you would have to look at what was lost by that single day.
That's my point, we are getting into facts. And so how can you say as a matter of law, 1 day later might be disproportionate, but 3 weeks, we shouldn't get into the facts at all?
Because there's a difference. The best I can say to that response, Your Honor, is there's a difference between 1 day and there's a difference between 3 weeks.
All right, so where's
In fact,
the line?
Well, I don't know, but it's greater than 1 day. It's greater than 1 day. But I think it's important to look at the context of the cases that find disproportionate breach. So the one case that was cited in the brief where you had the loss of $1 million worth of commissions for the failure to meet a deadline to return a laptop computer by a day. And you don't have that scale here. You have a much longer period of time that has passed, and you have issues that could have affected VGB.
It seems, just in this scheme of planning board approval, 3 weeks is pretty quick, actually, in terms of a delay, right? I mean, these things often drag on and on and on, so.
Sure, but where does it stop?
Well, but maybe that's a fact question.
But that's the problem. So if are we to tell people going forward, don't worry about putting dates in your contracts because the courts will go, we think that's fine. We think that's okay. We'll allow a little slide room. We'll give you a little slack here. The reason why we look for ambiguity in contracts and the reason why that's a threshold issue is because contracts have to be final. We owe it to people to say that if you make your contract specific enough, if you put in enough information, we as lawyers, we as the judicial system, you as judges, are not going to sit there and second guess everything that you put down.
But isn't your problem that some jurisdictions say, put time is of the essence language in your contract, and that's it, magic words, and that's very clear. And we have specifically said, we don't do that in Maine. You don't have magic words. So don't we always have to look at context to some extent?
I don't think so, because if we look at it through the lens of specificity and ambiguity, then I don't think we are automatically foisting the burden upon ourselves to open up every single contract that way. There are equal policy problems by requiring magic words. What if a party isn't aware of the magic words? What if we're two unsophisticated people trying to get an agreement down in writing and we didn't go to law school?
Then you can still have a fact question and decide what was meant.
It's a good idea not to have magic words, is what you're saying.
By looking at the context of what's been pled in the complaint. And what we have to be looking at here again is, Colbath and Raisin Memorial. If the parties went through the trouble of putting down a date, not just, hey, we're going to try to get this thing done by then,
Then you're saying if you put down a date, time is always of the essence? Is that your pronouncement of what our law is?
I would say, not my pronouncement of the law, I'd say that what I'm reading in the law is that if you put down a date and if there are consequences associated with not hitting that date, then that matters.
But there weren't consequences for your client, and your client got the benefit of the agreement. And I understand your point that not all unit owners signed off on this, but one did, and she has a specific interest here.
There are consequences, not necessarily outside of the contract. There are consequences inside the contract. The contract says that if this date is not hit, then the obligations of the parties, both VGB and Ms. Beane, do not arise. And because those contracts are listed,
It doesn't actually say if this date is not met. It says if the conditions in paragraph 12, A through D.
Sorry, I didn't mean to speak over you, Your Honor. Connecting those two, I think, is not a leap. And I think Raisin Memorial and I think Colbath say that if there's a date certain and if there's consequences associated with that date in the contract, not outside the contract, then it's up to us to honor those words.
Thank you.
Thank you, Your Honors.
Attorney Bedard, do you
Thank you, Your Honor.
reserve 2 minutes?
I think primarily 2 points. One, VGB continues to suggest that somehow the complaint wasn't drafted properly. What I'm hearing is continual arguments more than he just made in the motion to dismiss, but not everyone signed. Other arguments. These are all condition precedent arguments. Well, you can't enforce it. My client signed and VGB signed. No one's disputing that. But he's saying you can't enforce it because all these conditions weren't met. Not everyone signed. plus the one we're arguing about today. That's an affirmative defense. I mean, as soon as you say, well, that's the problem of the person who wrote the complaint, that's not true. This says it's an affirmative defense, you raise it, you prove it, and the burden rests with VGB. So it's not proper to say all these issues should be brought up in a 12b6, only the ones that are clear from the face of the complaint, and I think there's only one that's clear. And that's why he's made that argument.
Can you address his argument that, people who enter into contracts need certainty and finality, and they've put a date in here that must mean something? Can you address his point there that if we let this go back, we sort of said, well, the date's meaningless?
Yeah, so I don't think that we interpret contracts so rigidly that we don't interpret them reasonably. You can put dates in to move people along, to say, we wish to meet it by this date. You fail to meet it by a few weeks. That doesn't void the contract. It never should. I mean, it's back to the disproportionate forfeiture, which is brought up again. 1 day is disproportionate. Disproportionate forfeiture says, what did my client lose on one hand, and what did VGB lose? They lost nothing in 1 day. If it was planning board approval 1 day late, 27 days late, they lost nothing. They can prove that they did lose more in those 1 to 27 days. And it was my client is losing everything. They're losing nothing. That's the point. They can develop factually that it's different. Same way you interpret contracts. You don't interpret them so rigidly that every date has to just be rigidly adhered to. That's, I think, the Associated Builder says if you miss it by a day or two, you miss it, a payment doesn't necessarily mean it's material. Other courts say the same.
Thank you, counsel. Thank you, counsel, this morning for this spirited argument. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. And with that, we're in recess for lunch.